Hello, future toppers. Welcome to the strict initiative of Civilsdaily to ensure consistency in your day-to-day preparation. My name is Santosh Gupta, and I will be taking up the prelims section of the strict initiative. I have qualified prelims in all my 6 attempts with a score above 120 by following a FCE approach, that is, factual, conceptual, and elimination approach in answering the prelims questions. And same we are going to do today in our questions. So without much ado, let's start. Today topics are High Court, Tribunals and Subordinate Courts. Let's solve some questions on these topics. First question, it is about the writ jurisdiction of Supreme Court and High Court. So here fact we have to know is that under Article 32, it is given Supreme Court writ jurisdiction, and under Article 226, High Court writ jurisdiction comes. But there is a difference. Supreme Court can issue only writs for the violation of fundamental rights. But High Court can issue writs not only for the fundamental rights but also for any other rights like legal or constitutional rights. And also for High Court, it is their discretionary power. But for going to Supreme Court, it is your right, but High Court will entertain your plea or not. It is up to them. So reading this statement under Article 26, so a statement 1 is clearly wrong. And writ jurisdiction of High Court is wider than Supreme Court. We just discussed. So your answer will be only 2. Coming on to next question. It is about the judicial review of power of High Court. We know that in the Constitution, both Supreme Court and High Court have the power to review the laws or executive actions of executive. So, statement 1, High Court can only review the laws enacted by state legislature only and not the ones enacted by center. So here focus on the statement only. Whenever there is a statement only in the statement, you have to be very careful. High Court can review the laws of union government if it affects the territorial jurisdiction of the particular High Court. Suppose a central law such as Section 377 related to criminalizing the gay sex was there. It was impacting the territorial jurisdiction of Delhi High Court. So it gave a judgment and declared that criminal part of 377 is null and void. Now statement 2. So statement 1 will be wrong. Statement 2. High Court cannot interpret the Constitution while reviewing any law or order passed by the government, as Supreme Court is the sole interpretation of the Constitution. This is also not true. High Court can also interpret the Constitution and pass any judgment or law by if it is not in concurrence with the Constitution, that shall be void. So here both 1 and 2 is not correct. So neither 1 or 2, that is D option. Let's take another question of tribunals. With reference to central administrative tribunals, consider the following statement. Here the fact you have to know is that 323A and 323B. Under 323A, center can create an administrative tribunals both for center and states. Center means here the parliament. But 323B, the state legislature also have power to create tribunals other than administrative tribunals. This is the fact we are supposed to know. But if you focus in the statement here 3, it says the appeals against the order of CAT can be made only in the Supreme Court of India. So if you are knowing about the case, there was a case, L. Chandra Kumar case, where it was given order that all the appeals from any tribunals in India will lie to the appellate jurisdiction of High Court. So all the judgments of CAT or any other tribunals will lie to High Court of that region. So clearly the statement 2 is not 3 is not true here. So if you eliminate the option 3, then you can reach the option directly, that is A, 1 and 2. But let's go by the fact or our understanding. First, members of CAT have the status of judge of High Court. That is true. Members are drawn from both judicial and administrative stream. See, all the tribunals are supposed to follow the principle of natural justice, and they are the quasi-judicial bodies. We do not have to follow the exact judicial process that tend to delay the judgment. So that's why they have both judicial and administrative members, so they can apply their minds best and come to the resolution of problems as soon as possible. So statement 1 and 2 is correct and 3 is not correct. So option A will be true. Here L. Chandra Kumar case was the point. Next question on the tribunals. So here so many taxes are given. Which of the following categories: levy, assessment, collection, enforcement on any tax, foreign exchange, import, industrial and labor dispute? Which of those options are correct regarding Article 323? One way to go about this question is that remember the Article 323b is which of the tribunals have been created by the whether state or central government under this article. Other ways to know is that 323, using 323 any such of tribunals can be created, such as we have industrial tribunal, labor tribunal, we have foreign exchange tribunal under FEMA, we have custom tribunal, we have GST tribunal to hear the cases again the adjudication of GST. So that 1, 2 and 3 all will be true here, because under 323 both center and state can create tribunals other than administrative tribunals for all of those given here. So all of the true. Next question on subordinate courts. Let's read statement one by one. He possessed original and appellate jurisdiction in both civil and criminal matter. This is true because district judge is the head judge of the chief judge of the district judge, and when he act as a judge of the criminal court, he is also known as the sessions court. This is from from the book. This is a question from the book. He possesses original and appellate jurisdiction in both civil and criminal matter. That is true. He hears the civil judgment from the municipal court or criminal judgment from the judicial magistrate. He has supervisory powers all subordinate court in the district. So like High Court have the supervisory jurisdiction over all the district judges within the state. Similarly, the district judge has supervisory jurisdiction over the all subordinate courts, and he also hear the appeal in both civil and criminal matter. Capital punishment passed by him is subject to confirmation by High Court whether there is an appeal or not. Yes, this is also true that any capital punishment judgment are reviewed by the High Court to give an extra protection within the Article 21. So here both all the three statements 1, 2 and 3 are true. Here you have to know that within Article 233 to 237 the regulation of subordinate courts are done, where three-tier district hierarchy of courts exist. To know more about the evolution of our judiciary within the district, you can read the Cornwallis Code in the history also, where they have been much changed now. Thank you for watching today's video. If you have any doubts about the question, you can let us know in the comment section. And if you want to join mentorship program that is Super 25 under me, you can follow the link given in the description or fill the Samanway form so that a mentor can get in touch with you. Thank you.
Subscribe to our YouTube channel and press the bell icon on the YouTube app and never miss another update from Civilsdaily.